Hello friends, I am Arpit and I am here with today's analysis. Today is 14th of June and we are going to deal with two very important topics which are in news. The first is mercy petition. The President of India, Mrs. Draupadi Murmu, has rejected a mercy petition filed by a Pakistani national who was alleged to be involved in the bombings of Delhi in 2001. These bombings were done in Red Fort. The president, according to Article 72 of the Constitution, has these powers. The governor, along with the president, in Article 161, has these powers, but there is a difference. The governor cannot grant pardons if it is a case of court martial, if it is a case of death penalty, and if it is a case of a law made by the union government. These are the differences between the pardoning powers of the governor and the president. Next is the Neet UG 2024. This common entrance test of the students, more than 23 lakh students appeared for this year's Neet examination. And this examination is alleged to be full of irregularities. What kind of irregularities? Around, I would say, more than 50 students got a full score of 720 out of 720, and out of which multiple were belonging to the same center. Second is the grace marks. More than 1500 students have been granted grace marks. Under what circumstances? The National Testing Agency, which conducts this examination, cannot testify. So, a case was filed in the Supreme Court, and the Supreme Court gave directions to the NTA. NTA in the Supreme Court said that of those 1500 students who have been granted grace marks, we can conduct the re examination, but not for all. There was definitely not a paper leak as per the claims done by the NTA. But the problems are increasing and the students are protesting against this examination. So let's get started and see. President Draupadi Murmu has rejected a mercy petition filed by a Pakistani national, Mohammad Arif, who was sentenced to death for December 22, 2000 terrorist attack at the Red Fort. So, a grave act, no doubt about the fact that the most heinous punishment should be given to this person. So the punishment was given. The punishment given was of a death sentence, means he has to be hanged till death. And India is one among those countries in which this capital punishment, we call it in legal terms, is valid. It is given, and it is given for such kind of acts, a terrorist act, that is. The president's decision, although was made on May 27, came after Arif failed to obtain relief from the Delhi High Court and Supreme Court. So, the procedure is that if someone gets convicted of a death sentence by a lower court, let's suppose a district court, then that sentence of that person has to be approved by the High Court. Then only death sentence, or I would say Phansi, will be given to that person. Without the High Court's approval, it cannot be given. And once the High Court approves it, then that person becomes eligible for filing a pardoning plea with the president. Before that, that person also is not eligible to file a pardon plea with the president. And the president only is empowered to pardon a death sentence. That is what it is. So he went to the president after High Court and the Supreme Court both, forwarded or did not cancel his, death sentence. Now he can challenge the president's decision and prolong the proceedings further. This is what he can do now. Now, since the president has also rejected his petition, earlier the High Court rejected. Now the Supreme Court also did not, entertain this. He said that death punishment should be given. He approached the president. President has also rejected it. Now he can challenge the decision of the president in the courts. Well, according to the Bharatiya Nyaya Sanhita, the new, I would say, law which is going to be applicable from 1st of July, the president's order, or whatever the president has given or rejected this petition, these kind of things, they cannot be appealed in any court, according to the BNS, but it is going to be applicable from 1st of July. So, since it is not applicable, so he can challenge the president's decision and prolong the proceedings further. He can challenge the president's decision in the Supreme Court. Now, the pardoning power of the president. What is and how is the pardoning power of the president? So first of all, Article 72 of the Constitution gives pardoning power to the president. And in what cases can the president pardon? In all cases where the punishment is of court martial. Court martial is done of the military people who are convicted of a crime which is, I would say, heinous in nature. In all cases where punishment is given for violating a law made by the central government and its executive powers extend over there. So in these cases, basically, the president can grant pardons. The president can grant pardons, reprieves, respite, or remission of punishment, or to suspend, remit, or commute an offense of any person convicted of any offense. So all these terms, pardon, reprise, respite, remission, we'll see in the next slide. But yes, before that, let us compare the pardoning powers of the president and the governor. So Article 161 gives pardoning powers to the governor. But the governor cannot exercise these powers in case of a court martial, when a death sentence is awarded, and a law made by the union is there into picture which has been violated, and for that the convict has been convicted or the person has been convicted and the person is seeking pardoning for that. So law made by the union, governor does not have any jurisdiction. A death sentence is given, governor does not have any jurisdiction. A court martial is there, governor does not have any jurisdiction. In these cases, the appeal will go to the president only. Apart from these, it can go to the governor as well. Now, the terminologies which I was talking about, pardon. Pardon simply means president can completely absolve the charges and set that person free. Second is commute, to reduce the nature of punishment from a much harsher one to a less harsher one. For example, death sentence to life imprisonment. So this is commuted. Remission, to reduce the punishment without changing the nature of the punishment. Rigorous imprisonment for 15 years is remission to rigorous imprisonment for 10 years. The nature is same, rigorous imprisonment is there, but the tenure has been reduced from 15 to 10. So this is reduce the punishment. Reprieve, a delay is allowed to give convict some time to prove his or her innocence. Respite, to reduce the degree of punishment looking at specific grounds. Specific grounds can be pregnancy or old age. So these are the technical terms which you need to know. Remember, the governor cannot pardon a death sentence, but the governor can commute a death sentence to life imprisonment. This is what the catch is, and you need to understand this. So, the standards applied by courts during death sentence. So, in 1980, the Supreme Court, in this Bachchan Singh versus State of Punjab, upheld the constitutionality of the death penalty. Means death penalty can be given. It is constitutional. Judges should never be bloodthirsty. This should be taken into consideration. It should be saved in the rarest of the rare case when the alternative option is unquestionably closed and all possible mitigation circumstances have been considered. So this was the rarest of the rare case, a terrorist attack, bombings, in which basically two army jawans lost their lives, one private guard lost his life. So definitely that was an act of terror. The court has reaffirmed the rarest of the rare standards in several decisions. And, you know, the report of the 262nd Law Commission, published in 2015, also said that absolute abolition of death penalty for all crimes and other than terrorism related offenses and waging war should be there. Means death penalty should not be available for any, should not be awarded for any other crime except for terrorism. This is what the recommendation of Law Commission was. This recommendation is not accepted as of now. Okay. So death sentences are being given, but they are being given for other crimes also other than terrorism. The journey in courts of Muhammad Arif, who has, whose petition has been rejected. So, what has been his journey in the courts? So, in 2007, the Delhi High Court confirmed the trial court's decision to sentence Arif to death, and since the Delhi High Court, confirmed it, he becomes eligible for filing a pardoning plea to the president, because then only the person becomes eligible. Arif then appealed to the Supreme Court. He did not go to the president directly. He appealed to the Supreme Court. On August 10, 2011, a bench of justices V.S. Sirpurkar, T.S. Thakur rejected the appeal, calling the attack an undeclared war by some foreign mercenaries. So, two-judge bench, Supreme Court also did not rule in favor of Muhammad Arif. Providing a historical overview of Red Fort to highlight its significance as a national monument, the bench stated that even without any reference to any other case law, the case satisfies the standards of rarest of the rare, and hence death penalty should be given. Then Arif continued to file petitions in the Supreme Court against the death sentence which was being awarded to him by the two-judge bench. A review petition rejected by the Supreme Court in 2012. A curative petition was filed. What is a curative petition? Where the Supreme Court can only intervene if there is an error in its judgment. This curative petition was rejected in 2014. Again in 2014, Arif filed another writ petition, arguing that cases arising out of a death sentence should be heard by bench of 3 judges or more. Remember, there was a two-judge bench which reaffirmed Arif's death sentence. So he was wanting that death sentence is a heinous, I would say a very grave punishment, very big punishment, and for that at least 3 judge bench should be there. But the judgment was given by a two-judge bench. So he filed a curative petition that Supreme Court should correct its error. A 3 judge bench should be there. So finally, the Supreme Court agreed and formed a 3 judge bench. Supreme Court agreed to this demand. The case was then placed before a 3 judge bench led by former Chief Justice of India UU Lalit. And on November 3, 2022, that is 22 years after the attack, the bench rejected Arif's plea, finding that there was a direct attack on the unity, integrity, and sovereignty of India. So, summing up Arif's journey in the courts, Delhi High Court reaffirmed the death penalty. Supreme Court two-judge bench reaffirmed. Then 3 judge bench reaffirmed. Now he went to the president. President again reaffirmed, cancelled the pardon. Now he can again go to the courts as per the law, because the president's, I would say, pardoning power is subject to judicial review. Can Arif challenge president's rejection? Yes, as of now he can challenge. Arif has the option of challenging the president's rejection. But once the Bharatiya Nyaya Sanhita is implemented, there we have said that, or it has been written that, president's rejected mercy petitions will not be questionable in any court. At a procedural level, the apex court has held that president's power must be exercised based on the aid and advice of the council of ministers. So again, the president cannot act on his own and can be challenged on multiple grounds. First, relevant material was not considered while taking the decision by the president. The power was exercised based on political considerations, or that there was no application of mind. So these things can be there, and if on these grounds the petitioner files against the president's order, then that person can file. Has the Supreme Court commuted death sentences? Now, has there been such kind of instances where the president has not done anything and the Supreme Court has come and intervened? Yes. The top court has also commuted death sentence in cases of inordinate delay in deciding mercy petitions. This happened in Shatrughan Chauhan versus State of UP in 2014. Court also commuted the sentence of one Gurmeet Singh after he spent 27 years in custody and 21 years on death row. The court found that there was an inordinate delay in deciding his mercy petition, which was disposed of in March 2013, more than 7 years after the Supreme Court first upheld the death sentence. So there have been instances. Now we move on to the second topic, that is Neet UG 2024. So this exam was conducted May 5, and this exam is believed to be full of irregularities. More than 50 students scoring full marks, 720 out of 720. More than 1500 students getting grace marks under mysterious circumstances, which cannot be proven. So there was a lot of hue and cry among the students. And finally, a case has been filed in the Supreme Court. And the Supreme Court on June 13, heard that case. The union government submitted to the Supreme Court that the scorecards of 1563 candidates who were given compensatory marks or grace marks in the common undergraduate medical entrance examination, NEET UG 2024, held on May 5, will be cancelled. Now, there's a choice that if these 1563 candidates want their score without the grace marks, that can be considered. If they want to give a re-exam, that can be done. But to these 1563 candidates only who have been granted grace marks, this facility is there. Another test will be held for them, likely on June 23. Results will be out by June 30 and counseling for seats can begin by July 6. These candidates will be informed of the actual score without the grace marks and they can choose to take another test. If they opt not to sit for the retest, their scores without the grace marks will be the final score. This is what it is. Means these students, these 1563 candidates have been given a choice. Your score without the grace marks, you want it considered, you can consider them. You want to give a retest, it is your call. You can give a retest. So this is what it is. Now what happened? The court was hearing petitions challenging the award of grace marks to 1563 candidates from 6 NEET centers in the country using a normalization format. What was the grounds for granting grace marks? The grounds that they were not allowed the full period of 3.2 hours to write the exam due to technical issues. Based on a court order only, the compensatory marks were awarded to these candidates on the recommendations of a committee constituted by the National Testing Agency, which is responsible for conducting this exam. This National Testing Agency is an autonomous body under Ministry of Education, and not only it conducts this NEET exam, it conducts JEE, Joint Engineering Entrance Examination. It conducts CUET as well, and it conducts examinations for various central universities like Delhi University, Jawaharlal Nehru University, and all. So it is like this. It was charged that the grant of grace marks was arbitrary and not transparent. So that was basically the main issue. Are there any other charges on NTA? In NEET, students have to answer 180 questions. MCQ types they are 720 marks, means every question is of 4 marks, and there's a negative marking of 1 mark. So 720 out of 720, person getting all the questions correct and no answer wrong. Students are claiming that this is humanly impossible because more than 50 students are getting this. And other students have scored 718, 719 marks, which is mathematically not possible. But yes, NTA states that we've given them grace marks. And that has unearthed the scam, or that has led to a lot of widespread protests among the students. Hence, only certain marks can be scored by candidates. It was the grace marks that caused the confusion, the NTA admitted. However, this is not the only charge or case in court against NEET 2024. This year, there has been a litany of charges that go beyond a question paper leak. And what are these charges? The slow distribution of question papers, providing wrong question paper, wrong OMR sheets, technical delays. Post evaluation, there have been complaints about the unusually high number of students, 67 students, who hit the perfect score of 720 to 720, and about students who scored statistically impossible marks, 718, 719, not possible to get those marks. Okay. So these were the cases. Other cases pertaining to the question paper leak are still to be heard by the Supreme Court. But yes, there have been largely, these kind of clarifications that paper leak was not there. So it is to be understood. In the past, the exam has been dogged by charges of poor organization and inadequate planning. Besides, inconsiderate rules on which candidates are allowed to wear in the exam hall or what they are not allowed to wear. These kind of rules were there. So in the past years, due to these things, this exam was in controversy. Now the aftermath of this conduct of examination and these kind of irregularities when they were unearthed. Now, all these charges sparked protests from the students and political parties across the country. So obviously, opposition political parties will be there. The Congress Youth Morcha is spearheading these protests. Political parties called for a fair investigation of the charges and called on the government to conduct a fresh NEET exam. Students had the same demand to reconduct the test on the grounds that the question paper leak had facilitated some students scoring full marks or giving them an unfair advantage. In response, NTA had appointed a 4-member committee. And this committee has already given recommendations, and these recommendations were tabled in the Supreme Court also yesterday. So, what NTA has said in the courts, let us understand this. NTA officials attributed an easy paper for 720 out of 720, 67 students getting. Very easy and convenient. NTA constituted a 4-member committee to go into the truth behind the allegations made this year. The panel found that the compensatory marks awarded to the 1563 students resulted in a skewed situation. That is it. Beyond this, it did not say anything else. Grace marks had to be limited to the attempted questions alone. And while the panel did not comment further on how many marks were granted in compensation, it seems that these grace marks were awarded for unattempted questions also. That is how, or that is where the irregularities are. And beyond this, this committee has not said anything. It concluded that it would be best to cancel the test for these students alone, the 1563 students who have been granted grace marks. And that is why this is basically what is being pursued. The students' demand. Students are demanding a complete cancellation of NEET 2024 examination and a complete reconduct of this examination. Okay. And they are not happy with the cancellation of the examination for a few students only, arguing that if the exam can be cancelled for 1500 students, then that is an admission of error. And therefore, they claim that the logical thing would be to cancel the May 5 exam for all candidates and conduct a retest. Will a retest be conducted? Let the time decide and let the courts decide. In my personal opinion, it should be reconducted. MCQs now. Now, which of the following statements is true? Mercy petition against death penalty can be filed with the governor only when the High Court of the state has approved the sentence. Article 161 of the Constitution gives the governor the power to pardon a sentence. Very carefully and I would say very nicely read these statements and concentrate on these statements, each and every word, and then answer the question. This is the biggest hint I could give. In which of the following cases the president can pardon them, but the governor cannot? A death sentence, a court martial, a union law, or all of the above. A curative petition can be filed in which of the following scenarios? When the petitioner is not satisfied with the judgment, when the petitioner appeals to correct an error in the judgment, when you want to appeal to a larger bench, or D, none of the above. Which of the following ministries administers NTA? Ministry of Human Resource Development, Ministry of Skill Development, Ministry of Home Affairs, none of the above. And the last question is, which of the following examinations are conducted by NTA? JEE, CAT, CUET, or both A and C? The last two questions, you will find nothing of these in the notes. But yes, watch the videos carefully. You can find answers to these questions. And with this, we come to an end of today's session. I will be seeing you tomorrow now with more such informative news pieces. Till then, you guys very well know what to do. Keep studying, keep reading, keep writing, and most importantly, keep revising. Keep watching the videos as well. Namaste. Jai Hind.